Most of the 1215 Charter and later versions sought to govern the feudal rights of the crown over the barons under the Angevin kings, and in particular during John's reign. The rights of the king had frequently been used inconsistently, often in an attempt to maximize the royal income from the barons. Feudal relief was one way that a king could demand money, and clauses 2 and 3 fixed the fees payable when an heir inherited an estate or when a minor came of age and took possession of his lands. Scutage was a form of medieval taxation. All knights and nobles owed military service to the crown in return for their lands, which theoretically belonged to the king. Many preferred to avoid this service and offer money instead. The crown often used the cash to pay for mercenaries, the rate of scutage that should be payable, and the circumstances under which it was appropriate for the king to demand it, was uncertain and controversial. Clauses 12 and 14 addressed the management of the process. The English judicial system had altered considerably over the previous century, with the royal judges playing a larger role in delivering justice across the country. John had used his royal discretion to extort large sums of money from the barons, effectively taking payment to offer justice in particular cases. And the role of the crown in delivering justice had become politically sensitive among the barons. Clauses 39 and 40 demanded due process be applied in the royal justice system, while Clause 45 required that the king appoint knowledgeable royal officials to the relevant roles. Although these clauses did not have any special significance in the original charter, this part of Magna Carta became singled out as particularly important in later centuries. In the United States, for example, the Supreme Court of California interpreted Clause 45 in 1974 as establishing a requirement in common law that a defendant faced with the potential of incarceration be entitled to a trial, overseen by a legally trained judge. Quote, "Royal forests were economically important in medieval England and were both protected and exploited by the Crown, supplying the king with hunting grounds, raw materials, and money. They were subject to special royal jurisdiction and the resulting forest law was, according to the historian Richard Huscroft, harsh and arbitrary, a matter purely for the king's will. The size of the forests had expanded under the Angevin kings, an unpopular development. The 1215 Charter had several clauses relating to the royal forests. Clauses 47 and 48 promised to deforest the lands added to the forests under John and investigate the use of royal rights in this area, but notably did not address the forestation of the previous kings. While Clause 53 promised some form of redress for those affected by the recent changes, and Clause 44 promised some relief from the operation of the forest courts. Neither Magna Carta nor the subsequent Charter of the Forest proved entirely satisfactory as a way of managing the political tensions arising in the operation of the royal forests. Some of the clauses addressed wider economic issues. The concerns of the barons over the treatment of their debts to Jewish moneylenders, who occupied a special position in medieval England and were by tradition under the king's protection, were addressed by clauses 10 and 11. The Charter concluded this section with the phrase, "Debts owing to other than Jews shall be dealt with likewise." So it is debatable to what extent the Jews were being singled out by these clauses. Some issues were relatively specific, such as Clause 33, which ordered the removal of all fishing weirs, an important and growing source of revenue at the time, from England's rivers. The role of the English Church had been a matter for great debate in the years prior to the 1215 Charter. The Norman and Angevin kings had traditionally exercised a great deal of power over the Church within their territories. From the 1040s onwards, successive popes had emphasized the importance of the Church being governed more effectively from Rome, and had established an independent judicial system and hierarchical chain of authority. After the 1140s, these principles had been largely accepted within the English Church, even if accompanied by an element of concern about centralizing authority in Rome. These changes brought the customary rights of lay rulers such as John over ecclesiastical appointments into question. As described above, John had come to a compromise with Pope Innocent III in exchange for his political support for the king, and Clause 1 of Magna Carta prominently displayed this arrangement, promising the freedoms and liberties of the Church. The importance of this clause may also reflect the role of Archbishop Langton in the negotiations. Langton had taken a strong line on this issue during his career.